Friends, I just pressed the let's go live button, which means we got to wait for the stream to fire up all across the fruited plain of the internet and make sure that we're alive on the Rumbles, the YouTubes, the locals, and the Telegrams. And it looks like we are alive and well. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Trump beating Judge Chutkan. Oh, and this was a doozy, man. This one just came out fresh out of the oven, and I am so excited to get into it because it is not a good day for Judge Chutkan. Jack Smith is not happy about this one because Trump has been saying you've got to stay the January 6th case. Everything that was happening right now, the deadlines for SEPA, discovery, and blah, 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 all the things, all on hold because Trump has been successful in making the point that the appeal stays the proceedings. And so Chutkan today came out, issued an order that we are going to go through. Very, very interesting order. She's just sitting here, typing this order out. I can just picture it now. Jack Smith is throwing printers out the window. And so we're going to go through it because Trump issued his reply. Then Judge Chutkan stayed the trial. Everything, though, except the gag. Right now, this is very fun. The gag order apparently is still in effect. We'll see what she says about it. And then we have this supercut from Tom S. Elliott over on the X platform. He's a great account to follow. And he put this supercut together from Grabian.com. And it's all of a bunch of other witnesses all talking garbage against Trump. But Trump can't talk garbage against them because he's been gagged thanks to Judge Chutkan. And so we're going to see what's happening there all in the first segment. Good news, good day for Trump, man. That March 4th trial looking like it's not going to happen. Unless, I mean, it still could, like it still possibly could. You know, something could happen. The Court of Appeals could accelerate this. But as it stands, pretty good day there for Trump. Not a good day for Jack Smith. We're also then going to see what Trump is doing at the Court of Appeals because the Court of Appeals is hearing on the immunity issue. And the immunity issue, if that comes back down, either way, it could accelerate the trial or it could, theoretically dismiss the case. We know simultaneously this has been appealed up to the Supreme Court. And so we'll see what the Supreme Court is doing about this as well. They also took up another very important case related to January 6th, an issue we've talked about here related to the word corruptly and whether the J6ers were actually acting corruptly in a manner that fits the statute, whether they're, can be charged with crimes. So if SCOTUS says that this was interpreted incorrectly, hundreds of January 6 cases may be thrown out. And that would be a very good day for justice. We've got another couple clips. This one, Hunter, showed up in front of Congress today. He had a deposition that was ordered by Congress. He was supposed to testify today, and he got so close, man. Look at him, how close he is. He's standing outside there with his protector lawyer, and he has a statement that he's going to read through there, very dramatic, and I think he sheds a tear or something. And then he just walks away, and we're like, hey, hello, my man. Like, you just turn around, walk in the door, like right behind you. Like you said, I'm here to testify. Well, turn around, go inside. Go do it. So we'll see what happened there. I've got a bunch of clips on it. He speaks for about 5 minutes. We'll listen to it. And we'll see what the Congress is going to do about it. Because this is actually kind of an interesting move from Hunter. I kind of got to give his attorney credit. It's like, hey, you want me to testify? How about this? I'll show up and testify to the press right in front of you. And so, then they ran away like little schoolgirls. But still, the first part of it, which is, kind of not very nice to the schoolgirls out there. But it's still their tactic, their maneuver. And the question is, what is Congress going to do about it? Because they said they threatened contempt, and we'll see if they actually get there. We have Congress's response. I've got the Judiciary Committee queued up. Old Biden said when this puppy happened previously, you would indict those people if they denied a congressional subpoena. Joe said time to indict them. And then Hunter Comer is going to explain his take on Hunter. And so we'll see what's going on there. And then lastly, we'll check in. We'll see what's going on with the impeachment. I know that it is being launched right now. Speaker Johnson's explaining this is the direction that the Republicans are going. It just got voted out of committee, the Biden impeachment resolution called H.R. 918. Tom Cole from Oklahoma introduced this puppy. And so we'll see what's happening there in Congress out of the House of Representatives and whether it gets voted on and passed today. I still don't know if that's happened or not. I think it's still in session right now. So as we're going through, we'll see what's happening. And then Pelosi, I'm pretty sure she's drunk in this clip, but you'll have to be the judge. I don't know. You can kind of see that eye. Looks like some nystagmus there that, might be from the vodka. Who knows? But we've got a lot to get to. As you can see, we got 4 segments. We'll go through them relatively quickly because the legal stuff is not too heavy lifting, pretty light stuff there. But we had a great members-only stream this morning, my friends. If you missed that, we're talking about some cool stuff, building out some cool projects there, watchingthewatchers.locals.com, and for our YouTube members. And so we'd love to have you. We do member streams in the morning. We do Saturday streams. We do cool stuff. So come join us, watchingthewatchers.locals.com. If you care to join us, and we'd love it if you would. It's a great way to connect and meet other watchers out there in the community. And if you're on YouTube, don't forget to grab the Telegram link. So navigate over to the community tab, scroll down, grab the Telegram link, and we'll look forward to seeing you there for the after party. We also have after parties for our membos. Also want to invite you to check out the new shop at robertgovea.com. You see, if you go to the website, we've got this new tab up here that says shop right up here in the top right. And if you want to get a new shirt, a deprivation of rights shirt, or a watcher hat, which that's my daily driver right now. It's this one right here. Boom. And it's good, nice quality, man. It looks good when it's on, feels good, nice and tight around the head. You can also get a gift card, and you can buy these flip-flopping Hillary or flip-flopping Joe Biden sandals. These are also fun. They're nice quality. You can see they're printed quite well, and they look good. They're a lot of fun, and Bill Clinton is tucked away in there. And so you can get something, for a stocking stuffer or for taking out the dog out there, supported by Hillary and Joe. And so we've also got this shirt, the Ungovernable shirt, and we'd love it if you checked it out. It's a great way to support the show, get something cool that you can sport. And if you're curious about what this watcher symbol looks like, when you click this, we're gonna release a video on this, but when you go here, you can read about the symbol, about what this means. It's Lady Liberty. It is inspired by the Roman goddess of freedom, Libertas. Also, it embodies the sword, the shield, the sword to cut through the bonds of ignorance, and so on. We put some thought into it. So check it out. And that's some of the things we stand for here. So that's a great way to support our work. robertgovea.com/shop. Now, let's get to John. John prefers the black hat. Now, the black one's good too. I like the black one too. Don't get me wrong. It just depends on what I'm wearing, And I've been wearing stuff that's the double color kind of matches. Anyways, good stuff, man. And send some pictures too if you got them out there. I'd love to see some pictures on them. All right. Now, let's get into the great news of the day. Trump beats Chutkan and Jack Smith. They are not having a good day. Judge Chutkan issued an order saying that Trump is right. Trump said, you can't have any January 6th trial in March, you crazy. I'm appealing your rulings on presidential immunity and other things. And by appealing it, it pauses everything, literally everything. Okay, no discovery, no SEPA this, no this, that, the other. None. You're done. Because Trump is freed from the burdens of litigation while it is on appeal. Now, Jack Smith, as we've been covering here, filed a bunch of motions, and now he's freaked out about this. He's like, we have to have trial in March, the day before Super Tuesday. He's so freaked out, he took this up to the Court of Appeals, and he took it to the Supreme Court simultaneously while he was replying to Judge Chutkan that we covered previously, saying, Judge, don't listen to Trump. You can still keep the train on the tracks here. Keep the trial in March. Well, Judge Chutkan came out and said, sorry, Jack. Trump's right. Oh, and that stings for them. Oh, man, they're not happy about that. And so we're going to see here, Chutkan agrees. Now, it's a 3-page order. We'll get there, but it's going to be much more satisfying if we see what Trump's final word was, because he dropped this today as well. He said, all right, Judge, this is the last word. And we've seen Trump's responses on this previously because Trump has been very aggressive, I would say. Trump has been saying, Judge, you don't have any choice at all. By virtue of our appeal and the rules, is taken out of your hands. And Jack Smith got very nervous about that. So we see this is a 9-pager out of Judge Chutkan's courtroom, District of Columbia, United States of America, Jack Smith and the deranged thugs of the DOJ versus Donald Trump. Saying this is President Trump's reply in support of the motion to stay the proceedings. Now, we're going to read Chutkan's order as soon as we're done. But here is their final word. They say, all right, Judge, as she's sitting there editing, she's like, are you sure we can't deny this? Are you sure there's nothing else we can do? Her court clerks are like, sorry, Judge, it's like the Supreme Court. Trump and his team says, all right, Judge, listen. You know, hours before initiating proceedings before the Supreme Court, Jack Smith, as he did, in order to try to complicate Trump's as-of-right appeal in the D.C. Circuit. Okay, Jack Smith tried to leapfrog Trump and to go right to SCOTUS because he's out of time. The prosecution filed an opposition brief that ignores Judge Chutkan, the Supreme Court's binding precedent, and it urges you to permit continued pretrial proceedings on a parallel track. And we read that in yesterday's show with Thomas Wyndham, subsigned by Molly, saying the prosecution's brief was ambiguous about what they had in mind, but today they filed a SEPA Section 6 hearing, which the court currently lacks jurisdiction to conduct. So they're saying, we don't really know what the government was asking for, but they're just like keeping the train on the track. Like you said, the train stops and they're driving it to the next stop. They said, hey, let's schedule the SEPA hearing. And they're going, what? No. Judge Chutkan, you don't have jurisdiction over this, like at all. You can't even hear the case, even if you wanted to. So notwithstanding the prosecution's overlapping and still pending motions, says the court currently lacks jurisdiction to resolve those too. Now, the only coherent principle that emerges from Jack Smith's filing, only coherent, is based on strategic gamesmanship rather than on the law. They're acting on behalf of the Biden administration, saying the prosecution will do everything that it can to rush an unconstitutional and fundamentally unfair trial to try to prevent President Trump from winning the 2024 election, which he is currently leading. Now, the prosecution's frivolous and unsupported opposition demonstrates their improper motivation and their desperation. That's true. The stay sought by President Trump is mandatory. When I appealed it, you had no choice. And the prosecution knows that. The court, they say, it says here, they quote it, must. You see that word, Judge Chutkan? See that? Oh, look at that one right there. Must stay its pretrial proceedings. And where did that case come from? Oh, look at that right there. The U.S. Supreme Court. That's what that symbol means. Oh, so that's pretty serious authority, isn't it? Must, not may, must. The scope of mandatory stay is also clear. What does it cover? The entire case is essentially involved in the appeal of a motion that is challenging immunity and double jeopardy. That comes from Griggs. Where does that case come from? Oh, yeah, the Supreme Court, another one. So the many district courts faced with similar appeals and motions to stay after having denied immunity determined that a stay of all proceedings right there is also valuable. Now, they say, indeed, a district court issued exactly the type of stay that Trump requests here when Clinton was appealing a similar issue. The Jones versus Clinton case. That's the Clinton sock drawers. And so they say, look, it's happened previously. The Supreme Court makes it pretty clear. Sorry that you're trying to squeeze this one through here, but we are not buying it. This court must do the same and find that everything is stayed. Now, until the appeal is resolved, Trump's defense says, any further district court proceeding would be a nullity. You'd be wasting your time. It'd be void. All existing deadlines are no longer in force. Judge Chutkan, that's our order to you. And this court lacks authority to issue decisions on pending applications. You are done. To the extent that circumstances arise that Jack Smith and the deranged thugs there believe warrant lifting the stay, they can seek the relief at that time. Now, unless that unlikely event happens, however, the proceedings must be, and they are, stayed. Thanks, Judge. Now, here's the basis for this filing before we get to the judge's motion or order. Says here, the prosecution even concedes, as it must, because there's no case law that refutes it, They agree and admit that Griggs, the case from the Supreme Court, it applies automatically when you file a notice of appeal. You literally lose jurisdiction. The district court is divested of its authority over the case. It's gone. The prosecution, Jack Smith, they also admit that while the appeal is pending, President Trump, they acknowledge, they say, will not be subject to the burdens of litigation. Now, isn't that nice that these prosecutors will say that in one filing and then literally the next day turn around and submit a request for a SEPA Section 6 hearing? See that? Isn't that nice? Yeah, we agree that he doesn't need to be subjected to the burdens of litigation except for SEPA, which we're going to file tomorrow, and except for this, which we're going to dump over tomorrow. And we're going to dump a pickup truck of unrelated, unnecessary discover, another 2 million pages, down your gullet on your front porch. No, and so they're just talking out of both sides of their mouth, obviously. So they say here, it follows that even if Jack Smith is going to make these concessions as they've done, even though they're not acting like it, the binding precedent upon which they are based, they say that this case must be stayed pending appeal. That means everything. Trial and pre-trial proceedings as well. Comes from the Supreme Court. Now, here is what they say is specifically stayed and stopped. Bunch of stuff. They say, all right, Judge Chutkan, and she's reading this just fuming. Okay, you know those smokes that come out of your ears? Like Elmer Fudd, when he was chasing Wile E. Coyote, that guy, bursting at the courthouse, says, sorry, hey, Judge, hey, just wake up over there. Hey, due to the automatic divestiture of this court's jurisdiction, you're done. All existing deadlines are not in effect, and pending motions must be held in abeyance. Feels like they're kind of ordering the judge around, it's kind of nice. Now, this includes all existing deadlines and pretrial submissions should they become necessary following the appeal. Such as, and without limitation, Trump is not doing any of the following, just so you know. Further briefing on President Trump's pending discovery motions. We're done. We're not working on it. Motions for Rule 17 subpoenas. We're not even thinking about them. No subpoenas even being thought about. The reason why they're listing this is so that if something comes back on trial, like the Supreme Court comes back and says, in second thought, everything looks good. Trial can move on. Chutkan says, okay, well, I guess you don't have immunity, so trial's on for the 4th. Then Trump can say, everything from this moment in time, okay, everything, like this is the legal reason why they're articulating this so clearly, is they're saying everything from this date, from 12/12, just mark the calendar, however many days. So we're going to pause this trial, step out, go somewhere else, go vacation at the Court of Appeals, and then we're going to come back. We better find this exactly how we left it. Nothing better change. And you're going to see, right? So however many days that is. So let's say it's 2 weeks or 2 months or 4 weeks or whatever. We come back and the government's going to say, hey, we're ready to go. Like we're ready on all of these issues. Okay. They're going to say, we're ready on trial. And Trump's going to say, no, sorry. We stopped working on this whole list. Like this is our notice to you. We're not even looking at this. Don't even ask about it because we're on appeal. And so every date from between, the 12th up until, whenever this is, let's say January, is now, we got to go back to the drawing board, Judge. And now let's reconsider Motion 17 subpoenas, Rule 17 subpoenas. Now let's talk about discovery. Now let's talk about advice of counsel defense. Remember that issue that popped up? SEPA submissions and hearings, all that is delayed. Classified evidence described in his notices and so on. Any anticipated objections that you're expecting from our side, they're done. Any expert witness disclosures. We know Jack Smith wants to use Trump's alleged cell phone, apparently, that he had in his possession to say where he was pinpointed within the White House and evidently what websites he visited and so on. But Trump is saying, we're not telling you anything. Any suppression motions. Okay, we're going to be filing a bunch of those. We're going to try to get a bunch of evidence dumped. Any motions in limine, preliminary motions. We're not even thinking about those either. Any proposed voir dire, jury instructions. Remember, the jurors have already gotten notices. Hey, we'd like it if you're available here. A bunch of DC jurors are like, the Trump trial? Perfect. It's like going to Disneyland, which is probably their second favorite thing. Now, exhibit lists and objections are also not even thought about. Witness list, Trump's not providing. Any written questionnaires for jury selection. And guess what? Look at that final bullet point. Trial. Oh, man, that's so good. We're also not preparing for trial, Judge. Not even thinking about it. Thanks, though. Are you guys sure you don't want to do? No, we're not. We're good. Yeah, thanks for offering, though. So the court lacks authority, Judge. You have no basis to even address the pending motions. And any decision, if you issue a decision on this, would in effect be an advisory opinion that we could just dump into the garbage regarding the court's views and other aspects of the case that assumes away critical flaws relating to immunity and double jeopardy issues that are now on appeal. Okay, Judge, we think that, in other words, you don't have any authority because Trump has immunity, and that this case is not even lawful because it's already been tried in the Senate and Trump has already been acquitted on it. Now you're trying to convict him again. So until the Court of Appeals tells us differently, we're done listening to you. Thanks. Now, such decisions, if you did decide against us, Judge Chutkan, right, they're really like digging a line hint, and I love it. If you think about issuing such a decision, well, guess what? That's going to result in unprecedented confusion with respect to the procedural requirements that would typically follow from orders that are based on the appropriate exercises of jurisdiction. In other words, you're breaking the law. You're inappropriately exercising jurisdiction over something you don't have. Now, such as time periods for reconsideration motions or mandamus petitions or interlocutory appeals. Now, they need to consider and potentially pursue these options. And the need to do that is one of the burdens of litigation, and you're not allowed to impose any of that on Trump during this appeal. And by the way, don't listen to the government with their Rule 37 garbage. It's nonsense. Nothing in that rule supports their lawless proposal. The rule just simply recognizes the Griggs principle, all right? And the rule authorizes a district court to deny the motion after this, but they say it's inappropriate here. Now, the advisory committee noted that the rule will be used and blah, blah, blah. Now, therefore, this citation is yet another example of the government failing in their obligation to seek justice, right? The sensible course of this is it is obviously a mandatory stay. If there's a dispute about this in the future, that they believe that somehow this falls outside of the mandatory stay, then they can lift the stay at that time. But there is nothing here at this moment that justifies you keeping jurisdiction over the case. And saying, guess what? The government just can't litigate against Trump in absentia, right? Trump is working elsewhere. His team is no longer at the district court. They're at the Court of Appeals. Now, the government wants a parallel track. They just want this thing to just keep moving forward. Well, Trump needs to be there. Hello. It takes two to tango in a trial. So they say, look, ignoring these realities and without any legal authority, Jack Smith and the deranged thugs over there, they propose a bizarre one-sided proceeding where Trump is absent. Now, in their dream world, notwithstanding this court's divestiture of jurisdiction, which you have no authority over this case, the prosecution would continue to file false motions with inaccurate descriptions of evidence in order to harm President Trump's reputation and bolster President Biden's losing campaign. So good. Because the court doesn't have any jurisdiction. But they're like, can we keep sending you love notes, please? Hello? No, you can't. So it's bizarre. And they know this, right? And the court, they say, would make headway by just issuing a bunch of advisory opinions when the court doesn't even have any authority to address it. Saying ridiculous. This is flatly inconsistent with what the court has described in the rules. This politically motivated gamesmanship by Jack Smith and them driving this request is illustrated by the government's assertion that their purported plan to comply with the, quote, pretrial schedule, that it's subject to the length of the appellate process. Here, in other words, Jack Smith and Molly and Thomas, they ask the court to unlawfully reserve jurisdiction over Trump while at the same time reserving for themselves the option of ignoring the court's schedule if the appeal is not litigated in a manner they deem to be sufficiently expedited. So it's great. Saying, hey, you're basically asking the judge to take the case back from the Court of Appeals, which is very inappropriate. You just want her to keep moving this case forward when it's not hers, it's theirs. That's how it works. It's a handoff. Two people are not working on the same case simultaneously. But that's what they're asking Chutkan to do. And she's probably she was trying to figure out how to do it. We're going to get to her opinion next. So they say, look, the unprecedented suggestion here from them, these are our prosecutors who are supposedly swearing an oath to do justice. This is not partisan. This is not political. These are people who are, good-natured people, evidently, they tell us. But they're just saying that they file these motions. It is contradicting specifically the Supreme Court's recent admonition that it makes little sense for the litigation to continue if you're going to pause these things. Now, such a one-sided litigation where the government can just keep going while the defendant is on appeal, which would involve a prosecutor without a defendant, would be akin to a lock without a key, they said. A bat without a ball, a computer without a keyboard. In other words, it's not sensible. Hello. And so, yes, they say, the prosecution's nonsensical approach would not eliminate the burdens of litigation in a court that lacks jurisdiction. You don't even have the case. And here, any concept that this prosecution is serving the public interest is a joke. They say throughout these proceedings, Judge Chutkan, Jack Smith has regularly referenced the, quote, public interest, which, of course, is nothing more than a partisan private interest of the Biden administration in holding a show trial that falsely, unfairly, and unconstitutionally targets President Trump as he leads the 2024 race. Saying the special counsel was not elected, was not confirmed by the Senate. The prosecution has no mandate other than marching orders from Biden. The people didn't elect this guy, like the public, like, we elected this guy to go fix this problem. No. Senate doesn't have any say. It's not a representative portion of the public. He was appointed by Biden and Merrick Garland, and he took his orders from them. Now, under these circumstances, by wrongly invoking the interest of the public that the prosecution does not even speak for, they disrespect the interest of hundreds of millions of Americans like us in an unfettered 2024 election, one in which President Trump just happens to be currently the leading candidate. Now, the true public interest is in a legal proceeding based on traditional notions of due process and recognizing that all presidents must fearlessly and impartially deal with the duties of his office protected by the shield of executive immunity, like, we had for the last 234 years. Like that. That was a pretty good pattern until they wrecked it. And that is what the public is interested in, not cracking open our justice system and bringing it to its end, essentially, by weaponizing it. So for these reasons, the public interest is rooted in the proper resolution of the cases, not in rushing to trial. Rushing to trial is antithetical to that interest. They cite a case. They say, haste makes waste. It's an old adage. It survived because it's right so often. Now, any trial that is devoid of due process and the careful consideration of all legal issues would lack legitimacy, as we see. And such a trial would cause a further irreparable harm to a country that's already deeply divided and injured by the weaponization of law enforcement and the deterioration of our justice system. Saying that Jack Smith and the government's race and rush to judgment that was first evidenced by the line prosecutors before January 6 even happened. This was Molly and Thomas, right? In November 2020, they sent a letter claiming without basis, they sent it over to Bill Barr from the DOJ. They said that any fraud allegations about 2020 were false. They sent that in November 2020, like weeks after the election. There's no fraud. Did you even look into it? No, but we know there's not. Okay. Those same people just got gobbled up by Jack Smith, who's supposed to do this fair and independent investigation. No. He cobbled together the DOJ's, anti-Trump dregs and just threw them on a team. So they say, now that must not be confused with support for the prosecution's inaccurate claim about the public's strong interest in a prompt trial. Now, the appellate proceedings relating to the court's December 1 decision, including the matters that the special counsel, Jack Smith, recently dumped up to the Supreme Court, they say they're going to necessarily detract from the amount of time that the court contemplated for the pretrial proceedings. Now, the judge issued a scheduling order, we know, back in August, and said this is going to be perfect, right? We can have the trial in March. Now, insofar as a just outcome is objective, This will necessarily delay the trial. Obviously, trial's not happening, is what they say. Now, indeed, the court has already noted that backloading the pretrial schedule will not serve the interest of justice. And so, Trump's defense continues, wrapping up, they say, in cases of extraordinary public moment like this one, a party may be required to submit to delay, not immoderate in extent, not oppressive, if the public welfare will be promoted. Now, that concern overrides the abbreviated trial schedule. The public interest lies solely in holding proceedings consistent with due process, resolving legal issues correctly and in due course, and protecting the chief executive's ability to do their job. Issuing the requested stay, as required by law, Judge, is the only way to vindicate these interests. And so, Trump's lawyers conclude, before we get to Chutkan's response, where she admits they're right, they say the court should stay all further proceedings in this case pending the outcome of President Trump's appeal. Respectfully submitted, your friends, Todd Blanche and John Lauro. Great motion, very exciting to see that, and it's even more satisfying because they're right. This is what Judge Chutkan said. In response, Trump beats Chutkan. Chutkan admits it in this order. It's a 3-pager, and she writes, on December 4th, the court issued a memo and an order. Chutkan says, I told you that Trump's immunity and constitutional grounds was no basis for a dismissal. He was making arguments under those claims. Trump appealed that, and then he filed a motion to stay. And Chutkan says, for the reasons set forth below, the court will grant, in part, and deny Trump's motion. So she's going to grant a lot of this. We'll see what she keeps and whether she's allowed to do that. Now, the filing of a notice of appeal, and she's citing the same Griggs case from SCOTUS, is a jurisdictional event. It's not really, it's about what court has the case. It confers jurisdiction on the Court of Appeals, and it divests the district court of its control. Oh! She says in Coinbase, the case we're referencing here, which came out in 2023, the Supreme Court applied the Griggs principle to an interlocutory appeal and the denial of a motion to compel arbitration. Holding any further proceedings before the district court must automatically be stayed, right? That is a recent case. The court reasoned that whether the litigation may go forward in the district court is precisely what the Court of Appeals must decide. That's why you got to stop it. So it makes no sense for trial to go forward while the Court of Appeals is cogitating on whether there should even be a trial. And the court analogized that it's holding a similar in the context of appeals, things like involving immunity and double jeopardy, which happen to be the two issues at stake here. And so it just gets, better and better. Every time we see this, it's a beautiful thing, because what we're noticing is that immunity and double jeopardy were the very claims, the very arguments that they were making. They filed those motions first, and then they layered on the appeal. So, and they appealed on the basis, right? Very strategic. So as the DC Circuit recently made clear, a former president's absolute immunity would constitute an entitlement not to stand trial or burdens of other litigation. And so, thus, because Trump has appealed this court's denial of that immunity, whether the litigation may go forward in the district court is precisely what they may decide. So, consequently, Judge Chutkan agrees. She says with both parties, interpreting Jack Smith to really be on Trump's side, saying that Trump's appeal automatically stays any further proceedings that would move this case towards trial. There it is. Automatically stay any further proceedings that would move this case towards trial or impose any additional burdens of litigation. So everything that Trump listed there, pretty nice. Accordingly, writes the judge, and for clarity, just to be clear, the court hereby stays the deadlines that I already issued in our previous pretrial order. And that is good news for Trump. Now, the court emphasizes two limits on this stay. Now, first, As Trump says, the stayed deadlines and proceedings are, quote, held in abeyance, their language. Now, rather than permanently vacated. So if anything happens, I'm bringing those dates back. Now, if jurisdiction is returned to this court, she's like, I will, consistent with our duty to ensure both a speedy trial and fairness, I will consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial scheduled for March 4th. So I'm like putting a pin in those, man. And if I have any basis for reinvigorating those dates, reestablishing those, I'm going to do it for fairness and speedy trial, and fairness to the parties and blah, blah, blah. But what Trump would do is Trump's going to come back and say, look, any time from December 12th or 13th, when this order is issued, up until whenever this comes back down, so let's say it's January, or let's say it's 2 weeks or 1 week or 2 weeks, they're going to say, oh, Judge, come on. We got to move the trial out 2 weeks or 3 weeks or a month, right? The longer that they can delay any action or any jurisdiction of Chutkan, the better. Because they're going to just claim more time. We weren't doing subpoenas. We weren't reviewing discovery. We had zero burdens of litigation. So we need the time that we lost. Like, you gave us a certain amount of time. We lost that time. We get it back. You got to move the trial. And now she's going to say, well, where's she going to move it to? Really hard to push it back. She's going to put it in, 6 months back, 3 months back? Now we're interfering with the Florida case. And now we've got other cases like the RICO case coming up in August. And now we've got the election right then. So is she going to schedule it right in the middle of an election? Maybe. It's Chutkan. Wouldn't put it past her. So we'll see. But the March 4th date is looking very iffy, and she is not happy about this. As we said, it's going to have to be taken away from her. And the Trump defense took it away from her. And they literally relied on a 2023 case called Coinbase. Great work. Now, second, the court does not understand the required stay of further proceedings to divest it of its jurisdiction to enforce the measures that it's already imposed to safeguard the integrity of the proceedings. You see that? So she's going to keep jurisdiction over the gag. So I can't really do anything else, but a gag is not a burden of litigation. It's management of the proceedings. And so this is just an imposed safeguard to the integrity of the proceedings. And I can also manage the defendant's conditions of release. I can also talk about protective orders, about discovery. I can also have restrictions on extrajudicial statements and protective jury procedures. I can do all of those things. Now, unlike, for example, requiring additional discovery or briefing, if I have orders and limitations on Trump over those, maintaining those measures does not advance the case towards trial, right? And part of this is, the process is the penalty, right? You're in shackles, even if you're not in shackles, when you're charged with a crime. When the government investigates you, you're burdened, right? There is a lot of pressure on you, cost of litigation, all the things. But she says, but this is not actually litigation. Now I'm just going to micromanage your life and what you can say. Now it's stuff that he already carries, these burdens. We've already established that. And so if a criminal defendant could bypass those by just asserting immunity and then appealing its denial, then during the appeal's pendency, the defendant could irreparably harm any future proceedings and their participants. So just go out there, as other people have said, just start, taking out witnesses, throwing them off rooftops, and then just claim immunity, I guess. All right. Now, she says, that said, now there is little precedent guiding the application of Griggs to the protective measures. The Ninth Circuit has said that they've transferred a motion to enforce a protective order back to the district court, even though the district court had jurisdiction over the merits decision below. Right? She's saying, so this is a kind of a questionable thing I'm doing, and just letting you know. But the parties have not identified, and the court is not aware of any, guiding precedent in this circuit on this issue. So I'm going to keep these things. And there's even less instructive cases in the context of an interlocutory immunity appeal. And so here, additionally, Trump does not appear to argue that the protective measures like the gag themselves are stayed. But if he asks the court reviewing his immunity appeal to take temporary jurisdiction over the enforcement of those measures as well, and the court agrees to do that, then Chutkan says, well, I'm going to have to give those up as well. And that was signed by Tanya S. Chutkan. Oh, man. I am sure she's not happy about that one. That is the ruling and the order from Judge Chutkan. Trump is victorious. And the trial date is looking like it is going to be very iffy in March. And so, great news for Trump. Very bad day for Jack Smith and the Judge Chutkan over there. And what's curious about this is Chutkan is holding on to things like the gag and saying that Trump is going to continue to be gagged, even though people like this continue to talk all sorts of bad things about Trump. This is a great clip from Tom S. Elliott on the X platform. It's a supercut from Grabian.com. And I wanted to play this because there's a lot of context here about Trump's gag. Trump can't say certain things about reasonably foreseeable witnesses. We really don't know who that is. Like, there's no public witness list that I've seen about who these people are that he can't comment on. So it's just kind of this amorphous concept. I don't know if Liz Cheney's on there. I don't know if Michael Cohen's on there. I have no idea. But there's a bunch of people here who are saying that Trump is the worst in the world. Talk about stochastic terrorism. Talk about agitating a crowd to take someone out. Trump made a comment about Areola's GF hanging out with Chuck Schumer, and they went bananas. Now listen to these people in this compilation of lunatics explaining how monstrous Trump is.
What would a second Donald Trump term look like?
Well, he cannot be the next president. Because if he is...
You can't imagine the things that he's going to do. Mexico, Canada. We can't go to Canada because eventually Canada will become annexed to America.
And shoot visitors to the White House. Yeah, that means he can shoot the First Lady.
We're going to see violence, the likes of which we didn't even see on January 6th.
Make it illegal to run against him, to throw his opponents in jail, to shut down the media.
He will make himself into the Fuhrer, and he will make everybody raise their hand and salute him.
Using martial law against the American people.
Terminate the Constitution.
To rewrite the Constitution.
Create mass internment camps.
Throw everyone into Gitmo.
Might be sent to jail, or their rights might be suppressed, especially minority groups in society.
You might have any number of things happen to you and your family.
Every one of us, our freedom, our liberty, none of us is safe.
It's going to have people around him executing against an enemy's list.
Assassinate generals.
Ordering troops to attack American citizens.
Trump's very well-armed and extremist base will try to kill people.
He's going to basically burn the house down.
He will unravel the institutions of our democracy.
Draw similarities between Mussolini and Hitler.
Adolf Hitler and Benito Mussolini.
Makes Donald Trump even more dangerous.
Wants to take away your vote. Senate and the House are immediately going to be paralyzed.
People will begin in their minds to censor themselves. They might say, well, maybe I shouldn't say this.
This is the end of democracy.
I think that could be the end of our democracy.
But democracy is dead if Trump is reelected.
Cozy up to Putin that democracy will be at risk.
The absolute destruction of the Justice Department as we know it.
The Justice Department could be entirely transformed.
I am really concerned about that.
Every person who was associated with the attempted coup elevated in the administration.
If he's reelected, he will curb transgender rights.
The end of the rule of law.
Arrest political opponents.
To persecute, not prosecute, but persecute his enemies.
Take a wrecking ball to the rule of law.
He's going to make the law. Everyone else will have to follow.
A vote for Donald Trump may mean the last election that you ever get to vote in.
To go after the independent and free parts of American civic life.
He would tear down our institutions.
Purge the government of employees.
Department by department effort to weaponize the powers of the government.
To use the military to quash protests.
Wow. Ridding the government of all democratic safeguards.
Junking American democracy as we have always known it.
That he would try to stay in office beyond a second term. That he would never leave office.
There's no question.
No doubt.
Trump is reelected, he won't leave.
Donald Trump will never leave office voluntarily.
And what that means is that everybody who wants us to remain a republic has to put every other thing aside and work together urgently right now to stop that from happening.
Amazing. Okay, so be sure, my friends, that you check out Grabian, okay? news.grabian.com. They're responsible for that mashup. I did not do it. It was incredible. If you want to follow the people behind it, a great follow is Tom S. Elliott there. Supercut saying that if Trump wins, America's over, man. It's all done. We're all done. We're all done for. And so certainly that is on my timeline if you want to go check that out and give Tom S. Elliott a follow because it was outstanding, right? They're basically talking about all the things they're doing to Trump. He's going to weaponize the Justice Department. You go, hello? He's going to imprison his political opponents. Hello? That's what you guys are doing. So they just don't, they know they're doing that. They just don't want it to happen to them, which is why they're so freaked out. And they are freaked out, man. All these indictments are not working and they're going, uh-oh, we cracked the seal. If we start indicting people, that means Trump, when he gets power, he can start indicting us. Uh-oh. And so not a good day for Jack Smith and Judge Chutkan. This is going to be a lot of fun. The Supreme Court is going to be hearing it, and we're going to talk about the appellate court next in our next segment. But my friends, thank you for subscribing wherever it is you're watching us. Thanks for checking out robertgovea.com, our website. We got a new shop there where we've got some amazing new gear. Learn about the Watcher symbol. Learn about the new gears that we've got. And thanks for getting something for the Christmas holiday season, supporting the show, and checking out the things that we're doing at robertgovea.com. We'll look forward to seeing you there and back here on the next one. All right. Now, we're sticking with Trump, but we're going over to the D.C. Court of Appeals. And I actually think there was just a recent filing on this one as well. And this was something that just dropped, I think, as we were coming out of the oven. Let's see here. Yeah, the Immunity Court of Appeals, Jack Smith has already responded as well. So we've got a new filing. So here's what we're pulling up. This is Jack Smith's latest filing, and this just got dropped. So let me get this saved and opened up and queued up because he literally just dropped this on the back of Trump's. And here is what it looks like. All right, so we got that one. And then Trump. Okay, so we got two things back to back. And this is Trump. Donald Trump objects to the Court of Appeals expediting his immunity case. We know Jack Smith really wants to get this thing moving. He needs the trial to happen in March. Judge Chutkan stayed a bunch of deadlines, but he is throwing a Hail Mary. If he can get the courts to act quickly, maybe they can get the trial in before the election. So he's racing in Chutkan's courtroom. He's racing at the Court of Appeals. He's waiting for SCOTUS to take the case. But this is where Jack Smith is getting objected to by Donald Trump. And so we're going to see, first of all, Trump's reply to Jack Smith's request to expedite things. Trump says, no, there's no rush. Pump the brakes, buddy boy. And then Jack Smith just issued his reply on top of Trump's response. And so let's get to both of them. Here is what Trump said in the District of Columbia Circuit Court, Court of Appeals, 16-pager. No oral arguments yet. We're just asking about whether this case is going to go fast or not. We know that we're appealed out of Judge Chutkan's courtroom, out of D.C. We're asking about the immunity issue and double jeopardy, and things are stayed in her courtroom until this goes forward. And so Jack Smith asked for expedited processing. He's like, can we do this like now, like tomorrow, like Saturday? I'm ready. Trump says no. We are here in opposition to Jack Smith's motion. Says, all right, listen, Court of Appeals, it's pretty simple. The prosecution has one goal in this case. It's to unlawfully attempt to try to convict and to sentence President Trump before an election in which he is likely to defeat Biden. Now, this represents a blatant attempt to interfere with 2024 and the presidential election and to disenfranchise tens of millions of voters who support Trump. Now, while pursuing a partisan goal, Jack Smith waited over 2 years to bring this lawless case, and then it sought an extraordinarily expedited trial calendar, demanding the jury trial begin in December 2023. He wanted trial like now, like tomorrow. Notwithstanding nearly 13 million pages of discovery and a litany of important and unresolved legal issues. And when we were reviewing the discovery case, remember that Walmart versus Visa was like 6 to 7 million. Remember that? Now, in support, Jack Smith made the same argument it makes now. They say that violating Trump's due process rights would somehow vindicate the public interest in a speedy trial. But they were wrong then, And they're wrong now. Now, this appeal does in fact present novel, complex, and sensitive questions of profound influence and importance. Whether a president of the United States may be criminally prosecuted for his official acts as president goes to the core of our system of separated powers and will stand among the most consequential questions that this court ever decides. Now, the manifest public interest lies in the court's careful and deliberate consideration of these momentous issues with the utmost care and diligence. And I love this. I think that they should take time. I don't know why they're rushing things so quickly. You need to go slow, especially when you've got an election coming up. So likewise, the public's interest in ensuring that President Trump, like all citizens, has a full and fair opportunity to develop and to present his arguments to this court. They say a rush schedule, as the prosecution demands, would vitiate these constitutional rights and irreparably undermine public confidence in our judicial system even more than it already has, saying this court should deny Jack Smith's motion to expedite this. Here's why. They say the court rarely grants expedited considerations in the first place. If you want to justify this, you got to have good reasons. The reasons must be strongly compelling. But here, every relevant consideration calls for the opposite, a measured, deliberate approach and not a reckless rush to judgment. Saying Jack Smith cannot and does not, and was not able to even argue that there's any irreparable injury here. We can go slow, no reason to go quick. They don't even tell us what standard that they'd want to use in the appeal. Instead, they cite the expedited appeal of the gag order, but that includes the First Amendment. And so expedited considerations was warranted in that case because it would be irreparable injury on that one, on the gag order. But there's no similar showing of irreparable injury here. On the contrary, Jack Smith's sole contention that it's urgent is a desire to maintain what they say is an unconstitutional trial date of March 4th. Now, specifically, Jack Smith contends that the public has a strong interest in this case, proceeding timely, and that there's an imperative public interest in timely trials. But Jack Smith doesn't explain why it is, quote, imperative that the trial begin on that date. Why does it need to be March? Why does it need to be 2024? The date of March 4th has no talismanic significance. Aside from the prosecution's unlawful partisan motives, there's no compelling reason why that date needs to be maintained, especially when Trump has other interests and the public has an interest in proper due process of this prosecution. Now, they say that Jack Smith is making arguments. He's citing some claims. He's citing two cases, but those cases don't even involve immunity, so it doesn't change our analysis at all. He says that case was terrible. And this case, this case is a fun case. We have this case, Strunk. And then we have this case. Now, Strunk did not therefore conclude that all interlocutory appeals in criminal cases must be expedited. And Jack Smith also cited Cobbledick and emphasized the importance of prompt resolution in those cases. But Cobbledick didn't have any basis here. Cobbledick's not even applicable here, Jack. So especially in other cases, we should go slowly. Expedited consideration would violate President Trump's due process rights. He has the right to investigate this and go slow. Now, from the outset, the prosecution and the district court have repeatedly infringed on Trump's due process rights by denying him time to prepare for this. The initial discovery that they dumped on his back porch was 11.5 million pages of discovery. And it's the equivalent, this is the Washington Monument comment, 11.5 million pages is the Washington Monument stacked on top of itself 8 times. And guess what? You also have 1 million pages to spare on top of that. Isn't that fun? 8 Washington monuments. Now, of copy paper, one on top of the other. It's a big building. Now, despite the enormous volume of the discovery, and despite taking nearly 3 years to perform its own investigation before suddenly dropping the charges in 2023, right? So the trial happens in 2024. The prosecution demanded an immediate trial, beginning just 4 months after its initial discovery production. We're going to give you 8 Washington monuments, and we'd like to go to trial tomorrow, please. Thanks. President Trump emphasized that it would be impossible to review such a vast quantity of material in the time demanded by the government. Likewise, President Trump explained inter alia that the unprecedented and complex nature of the charges would present numerous questions of first impression, significant time to brief. There are hundreds of relevant witnesses spread across the country and so on. But Chutkan didn't care. She says, well, nonetheless, over Trump's strenuous objections, she said, no, you can be ready in March 4th. That's because Molly, highlighter girl, highlighted all the documents, remember? She said, well, it's very organized. They're like, yeah, it's 8 Washington monuments, but it's like got tabs between them. It's like section 1 is the first Washington monument. It has a tab. It says this, evidence 1. And then you just turn the Washington monument over to get to the second section, and then turn it over again to get to the next one. And she said, it's like, you can read fast, like just read fast, and it's all already organized. So it was insane from a defense attorney perspective. Why every defense attorney in this country wasn't screaming from the rooftops, I don't know. At least in Washington, D.C., it's insane. But, Chutkan said, I feel good about it. So she said, so when they were there, Trump's lawyer said, I feel I need to put that on the record so that there's no doubt that in our judgment, the trial date is inconsistent with Trump's rights. And it's also like it's ineffective assistance of counsel. Like I can't even do my job as a lawyer, obviously. Now the court did it anyway, said, I don't care. We got to have this trial, acknowledging that the median time from case to commencement in Section 371 cases, nearly all of which are less complicated than this case, is nearly 26 months, right? So they looked up all the other cases out of DC, and they said, how long did those cases take? 26 months. So we go from August to March is what Chutkan said for a case involving the most extensive, most insane, DOJ investigation in the nation's history, as they always say. The most extensive in our nation's history, democracy. Then Chutkan schedules it from August to March? Come on. Now, in the time since, these due process and Sixth Amendment violations, they've only grown more pronounced. In 12 additional productions, including one just days ago, Jack Smith produced another 1 million pages of documents. We've got 13 million pages now. We also have thousands of hours of audio-visual content. And similarly, back in August, they inaccurately estimated that they would produce 225 or 250 pages total of classified discovery. But no, that's not true. It's been 1,000 pages of classified material. They just keep dumping it out. Now, nonetheless, the district court has repeatedly denied Trump's reasonable requests for extensions of time. She said, no, we're not revisiting the trial date. I don't care if you can't read your materials. But now the prosecution asked this court to compound those due process violations. They want you to expedite this in light of all of that. You want you to go fast so that you, Court of Appeals, can maintain their unconstitutional trial date. So this court should decline to do that. President Trump, like every other defendant, has a right to fully develop and present his arguments on appeal through the regular appellate process, and that right may not be set aside absent compelling justification. Now, a rush proceeding in service of partisan political aims presents no such justification, and the prosecution also ignores that the harm of expedited consideration would have on Trump's First Amendment rights. Right now, they say, listen, Court of Appeals, Trump has a dominating lead for the presidential nomination for the Republicans. He's also the leading opponent of Joe Biden. The March 4th trial date is scheduled for literally the day before Super Tuesday, one of the most critical dates on the Republican calendar. The potential trial is likely to last for months, and it will thus inevitably interfere with American voters hearing from a leading presidential candidate at the height of the campaign in derogation of their First Amendment right to get his speech. Not only Trump's ability to speak, but I want to hear what he's experiencing. I want to hear what he thinks about Areola's GF and what he thinks about deranged thug Jack Smith. I want to hear about it because he is the person who is the victim of the weaponized government. And so who best to advise us about what's happening other than him, which is why they try to gag him. Now, the First Amendment's constitutional guarantee has its fullest and most urgent application when we're talking about political campaigns, and the public interest weighs heavily against expedited consideration here. Say, in the history of the United States Court of Appeals, no president has ever been subject to a criminal prosecution for the exercise of his official responsibilities until now. They started it. Now, the question of whether Trump is immune from prosecution for his official duties is a novel question of law, exceptional sensitivity and importance, one that warrants careful and deliberate treatment, not some hyper-accelerated briefing schedule in a rush to judgment driven by partisan concerns. No. American history abounds with examples of presidents who were accused by their political opponents of so-called criminal activity. Goes back to the dawn of the Republic. Everybody says everybody else is a criminal. We all get it. Could President George Bush face criminal charges for defrauding the United States and for obstructing official proceedings, for allegedly giving Congress false information about weapons of mass destruction in Iraq to drag us into a war? Yeah, he should be charged. If Trump is being charged, go get them all. Could President Obama, for example, could he be charged with murder for allegedly authorizing the drone strike that killed Anwar al-Awlaki and his 16-year-old son, both who were U.S. citizens? Could President Nixon have been prosecuted for obstruction of justice for ordering the dismissal of Archibald Cox on the Saturday Night Massacre? Yes, charge them all. What about John Quincy Adams? Could he have been indicted and imprisoned for the, quote, corrupt bargain of adopting Henry Clay as his Secretary of State? Now, according to President Trump, the answer to these questions is no, obviously. Now, that's an answer that is deeply rooted in the doctrine of separation of powers, but Jack Smith and the prosecution, they disagree. These are questions of historic sensitivity and importance. They warrant the most careful consideration possible, not the breakneck speed demanded by the prosecution. And so, indeed, the prosecution's push for haste has already hampered thoughtful consideration of these issues. Now, in the court below, Jack Smith insisted on a highly expedited resolution of presidential immunity by the trial court, and they obliged. They ruled within 9 days. Now, the result was a hasty consideration by Chutkan of the issues that are overlooked here. And they made a series of fundamental errors. Now, to take just one example, the first argument from Chutkan and her analysis, it contradicts the Supreme Court. Hello. Chutkan reasoned that the absence of an express provision in the Constitution that granted official immunity, she said, well, it's not in the Constitution, so therefore there's no immunity. She said in her order, says there is no presidential immunity clause, she said. Now, the lack of the constitutional text is no accident. Well, that would say then, by this reasoning, it would say that the president has no immunity from civil suit, right, Judge Chutkan? But the Supreme Court has already rejected that in Nixon versus Fitzgerald. They said that the president has absolute immunity from civil suit. How did they find that if there's no clause? They explicitly rejected the argument that Chutkan is adopting. They said that the absence of an express immunity clause, they rejected the argument that the absence of the immunity clause implies the absence of presidential immunity. They said no. Instead, that presidential immunity is functionally mandated. It's incident to the office. It's rooted in constitutional tradition and the separation of powers, and it's supported by our history, obviously. But Chutkan doesn't like it. Now, moreover, members of Congress are the only officials whose immunity is expressly spelled out in the Constitution. She said, well, the district court's logic would say that other well-established immunity doctrines for executive officials, like, these people, police, prosecutors, judges, all of whom enjoy immunity that's not expressly provided in the Constitution, she'd throw all that in the garbage too. Now, similar errors of her court's, her opinion, her historical, her structural, and her textual analysis was terrible, as we commented on here. She said, there's no history that supports this. And like the paragraph before that was talking about Alexander Hamilton making that very argument. Now, such errors provide a cautionary note about the importance of careful consideration of these complex and historic issues. Haste makes waste is an old adage, but it's been survived because it works. Now, even if this court grants expedited consideration, don't give them the same schedule that they're asking for. We have a fun quote coming up. It says, even if the court grants consideration, which it should not do not adopt their schedule. They request an opening brief no later than this time. But that is unfair. Jack Smith's proposed schedule would require attorneys and support staff to work round the clock through the holidays, inevitably disrupting family and travel plans. It's as if the special counsel Jack Smith and Molly, they, quote, growled with his Grinch fingers nervously drumming, "I must find some way to keep Christmas from coming. But how?" From Dr. Seuss, How the Grinch Stole Christmas, Random House, 1957. Yeah, Jack Smith, with his deranged heart, 3 sizes too small. Now, even if the court grants the motion to expedite, which it should not, any such acceleration should be more measured and allow at minimum 20 days for a scheduling order. And so if you are going to pick up the pace, give us more time than what they're asking for. Now, the court deny the motion to expedite and give us a bunch more time, the 21 days according to the rules that we're entitled to. Signed, your friends, John Sauer, John Lauro, Todd Blanche, attorneys for President Trump. Jack Smith, the Grinch, who stole American justice from the Christmas tree. Typical. And so you see Donald Trump's defense attorneys, another one, very nicely done, submitted this to the Court of Appeals, and we'll wait to see what they say. Obviously, the expedited process here has been adverse and opposed to Trump's due process rights. And so hopefully the Court of Appeals will see it. And if not, well, we'll see what the Supreme Court says about that. So very, very curious. And that is what we've got. Now, Jack Smith also responded to this. And here is what that one looks like. Briefly, from Jack Smith, he's replying in a 10-pager, a little shorter. He says, responding to what we just read, he says, none of Trump's arguments in his opposition has any merit. Rather, consistent with public importance of promptly resolving this case and deep familiarities with these issues, expedited briefing is warranted since we can type these documents up fast. That approach is consistent, and so grant our request. They say Trump first contends that the case does not satisfy the standard to warrant expedition. But he says the court recently observed that any postponements could frustrate the public issue. And so we've got to move fast. Now, a prior appeal says that, this is interesting, it says here, Trump's suggestion, they say expediting this case furthers the constitutional value, whatever that means, of a prompt resolution of criminal charges. And the need for expedition serves the public interest in a prompt trial that has heightened importance here. Not only because of the nature of the issue, but because his appeal suspends trial proceedings, right? So they're admitting, like, we've got to get our trial date back on track. This is not good. Like, it's expediting just to get the trial back on track. But why do you need the trial to be back on track so quickly? What's the rush? What's the urgency? It's obviously political. That was Trump's point in his response. So they say here, it's not accurate that an expedited schedule prevents us from having due consideration. We know these issues. We've already extensively reviewed these things. And Trump has already publicly announced that he's immune. So we've already had status hearings. Trump did not adhere to a schedule. We filed a bunch of briefs here. Government responded. In other words, we can go fast. And so let's just go fast here. Trump also argues that if we expedite it, it's going to violate his constitutional rights. They say that they've got a lot of discovery. But when confronted with those arguments, the district court already dealt with that. All right, so lame. They're just saying, well, Judge Chutkan already dealt with that. You guys are copying, pasting her words. Come on. You got to make a new argument. Nothing about her schedule of the trial date raises a constitutional concern. The fact that there's 13 million pages doesn't matter. She said it was all highlighted, and so who cares? And finally, Trump says if the court grants expedited review, that it would make his brief due the day after Christmas. And they called us a Grinch, Your Honor. But if the court enters this, then his brief would be due on the 23rd, and he could file it early, and so then he can celebrate Christmas with his family. Nah. They're very upset about that. I have no one to celebrate with. So in any event, if the court expedites the appeal but provides additional time, please grant this and please schedule it quickly. Signed, James Pierce with Jack Smith's office. Jack Smith, the Grinch who stole justice from America. You see this one here, courtesy of Locals and John McGarvey in the House. Jack Smith, the Grinch who stole due process and justice from America. We're gonna save Christmas, my friends, and we're gonna save America at the same time. Thank you, John, for the assist. John McGarvey over on Locals. All right, this is the certificate of compliance, and this is what Trump and the government have submitted. Now it is time for us to wait for the United States District of Columbia Circuit Court of Appeals to make a ruling, and we will be here to cover that. As another aside, we're also waiting for the Supreme Court to issue a ruling on this one. They've accepted certiorari on Joseph Fisher versus United States. This was a big one today. The motion to proceed and the petition for a writ are granted. This goes to a major issue about the word corruptly and whether the DOJ charged that. So SCOTUS is taking that. Trump's got some good appeals going, and we see Chutkan lost her jurisdiction over the trial date. So it's a pretty good day for Trump, not such a good day for the government. We'll be here continuing to cover, my friends. Thank you for subscribing to this channel, wherever it is you're watching it. Thank you for signing up for our daily newsletter at robertgovea.com. Also, all the documents that we go through are posted at robertgovea.com in our show reports. So if you'd like to get those documents, head on over there. You can also access the mind map there as well. When you sign up for the newsletter, you should get a fresh link that will take you to the mind maps, and we'll look forward to seeing you here and there on the next one. All right, my friends. Now, let's see what happened with Hunter, because Hunter kind of just slapped his hand on Congress today. Let's see what this looks like from Hunter Biden. Hunter Biden defies Congress and snubs them and their subpoena, and he does it while he's standing right outside of Congress. Very, very disrespectful to James Comer and the Judiciary Committee. We'll see what they say about it because they had some reaction. Hunter was ordered to show up with a congressional subpoena to testify, and he did not. He kind of showed up, but he was just a couple feet away from going inside and doing the thing. The question is, what happens now that he has rejected their subpoena? Is he going to get indicted like Steve Bannon was? Is he going to get prosecuted like Peter Navarro was? He better. Here's what Comer said before the day's affairs. He said, look, this is before Hunter showed up. He said, all right, buddy, we have been clear. He posted this on December 12, 4:58. He says, listen, we've been clear. Hunter must appear for his depo, or the GOP Oversight Committee and the Judiciary Committee will initiate contempt of Congress proceedings. We'll see. We'll see. So this is what it looked like. Now, he was supposed to be there, and he showed up, and this is what it sounded like. And he's got a lot of bravado on it. I have to give his attorney and his defense team some props on it because it is a sideshow, right? It's going to give Jake Tapper an excuse to say every night on the air, well, he showed up to Congress. Well, he stood outside. He wanted a public hearing. James Comer, right? All of this. It's a big spectacle. His attorney is making a mess of the whole situation. He's, I would guess, causing the Republicans to fall back on their heels a bit. And we'll see what their reaction is. And he's also creating some gray area. So when this does get referred over, if it does, the DOJ can say, well, he was standing there on the front yard. Now we're going to watch this spectacle and listen to Hunter explain himself. This is what it sounds like as his attorney, Abby, walked him up to the stand.
Good morning. Mr. Biden is going to have a statement to make and will not be able to take any questions today. We appreciate you all being here.
No questions.
Good morning. I'm here today to answer at a public hearing any legitimate questions Chairman Comer and the House Oversight Committee may have for me. I'm here today to make sure that the House Good morning. I'm here today to answer at a public hearing any legitimate questions Chairman Comer and the House Oversight Committee may have for me. I'm here today to make sure that the House Committee's illegitimate investigations of my family do not proceed on distortions, manipulated evidence, and lies. And I'm here. Good morning. I'm here today to acknowledge that I've made mistakes in my life and wasted opportunities and privileges I was afforded. For that, I'm responsible. For that, I'm accountable. And for that, I'm making amends. But I'm also here today to correct how the MAGA right has portrayed me for their political purposes. I am first and foremost a son,
sorry guys,
a father,
sorry,
a brother, and a husband from a loving and supportive family. I'm proud to have earned degrees from Georgetown University and Yale Law School. I'm proud of my legal career and business career. I'm proud of my time serving on a dozen different boards of directors. And I'm proud of my efforts to forge global business relationships. For 6 years, MAGA Republicans, including members of the House committees who are in a closed-door session right now, have impugned my character, invaded my privacy, attacked my wife, my children, my family, and my friends. They have ridiculed my struggle with addiction, they have belittled my recovery, and they have tried to dehumanize me, all to embarrass and damage my father, who has devoted his entire public life to service. For 6 years, I have been the target of the unrelenting Trump attack machine, shouting, "Where's Hunter?" Well, here's my answer. I am here.
Go inside. Turn around.
Let me state as clearly as I can. My father was not financially involved in my business, not as a practicing lawyer, not as a board member of Burisma, not in my partnership with a Chinese private businessman, not in my investments at home nor abroad, and certainly not as an artist. During my battle with addiction, my parents were there for me. They literally saved my life. They helped me in ways that I will never be able to repay. And of course, they would never expect me to. And in the depths of my addiction, I was extremely irresponsible with my finances. But to suggest that is grounds for an impeachment inquiry is beyond the absurd.
That's
it's
not what
shameless.
we're suggesting. No, nobody's suggesting that.
There's no evidence to support the allegations that my father was financially involved in my business.
Financially.
Because it did not happen.
Well, there's some Chinese money in his bank account that came from
James
Biden.
Comer, Jim Jordan, Jason Smith, and their colleagues have distorted the facts by cherry-picking lines from a bank statement, manipulating texts I sent, editing the testimony of my friends and former business partners, and misstating personal information that was stolen from me.
It's a whole book, bro.
There is no fairness or decency in what these Republicans are doing. They have lied over and over about every aspect of my personal and professional life. So much so that their lies have become the false facts believed by too many people. No matter how many times it is debunked, they continue to insist that my father's support of Ukraine against Russia is the result of a non-existent bribe. They displayed naked photos of me during an oversight hearing.
Marjorie Taylor Greene.
And they have taken the light of my dad's love, the light of my dad's love for me, and presented it as darkness.
Let it out, Hunter.
They have no shame.
Let it out.
These same committee chairmen have engaged in unprecedented political interference in what would have already been a 5-year investigation of me. Yet, here I am, Mr. Chairman, taking up your offer when you said we can bring these people in for depositions or committee hearings, whichever they choose. Well, I've chosen. I am here to testify at a public hearing today.
Nice job.
To answer any of the committee's legitimate questions.
Well,
Republicans do not want an open process where Americans can see their tactics, expose their baseless inquiry, or hear what I have to say. What are they afraid of? I'm here. I'm ready.
Go inside. Okay, so he obviously didn't answer any questions. He just walked away and left. And this is what the end scene looked like. We had a couple clips of that. So he ends here.
Republicans do not want what I have to say. What are they afraid of? I'm here. I'm ready.
Okay, bye. His lawyer
Hunter,
grabs him.
are you willing to go across the street? Why don't you
go over there? Go over there. Are you going to even answer questions from us? He should have invited James Comer to come out. You know, he should have said, James Comer, come on out here. I'm right here. You want to ask me questions? Come ask me questions right now. I'll take any questions from the committee. I'm right here. Come take them right now in front of everybody. But he didn't even answer any questions, right? So it's a nice little gimmick. It's a nice little shtick there. I think it is a nice play. Like it's him sort of pretending like he's complying with the law. And a bunch of the smooth brains over there in the media are going to say, well, he was outside of Congress and he kind of complied with the law. And Comer did give him the option. And so they're going to really try to, create some gray area and make an argument that if they try to refer this over to the DOJ, that he did what he thought he needed to do to comply. Or, I'm just a dumb Yale lawyer. What do I know? So that is what Hunter said. Now, he just got in the car and left. You saw this clip here, which shows us that he just leaves. Hunter leaves after the press conference, just hops in the vehicle and he's out of there. So not actually answering any questions or doing anything that he said he's there to do. Hops in the car. Bye, Hunter. Thanks. Thank you. He says he's under unprecedented attack. You know what? You had multiple options to plead guilty to the most benign crimes ever. And now you're getting charged with just a small sliver of your actual criminality. And now you're saying you're a victim of political attack. All right. Well, as we heard, he said the word financially involved. That's the one that's catching everybody's attention here. Says House Judiciary says, this is a new qualifier that we hadn't heard before. And remember, they keep moving the goalposts, right? Karine said, no, he had no idea what his son did. No idea. Never even totally separated. Well, he kind of would, maybe talk with them. Okay. He would not only talk with them, but he'd also go to dinner with them. Okay. He would not only go to dinner with them, he'd also go to events with them and public events and long dinners and business meetings. Okay. Now business meetings, he's showing up. Oh, okay. But there's not, any evidence of what, right? And it all just slowly continues to compound. And here they say this is the qualifier, right? He was not financially involved. This is from Judiciary. He admits that he and his dad were not just talking about the weather. The president is the brand. The story continues to change. And Don Jr. had a nice comment about this. Are they going to charge Hunter? because Don Jr. showed up apparently 5 times to 5 congressional subpoenas. Here's what he said. You know, Hunter just refused to show up for the congressional testimony that he was subpoenaed to be there for. I look forward to the same amount of outrage from the media as they'd have if I blew off any of my 5 congressional subpoenas. But since they're covering for Joe Biden and his corruption, I'm not going to hold my breath. Obviously, right? And so the media is just going to take it. Hunter's a victim. Those dang Republicans are constantly attacking him. Here is what Congress said in response. And this was Comer, Jordan, Marjorie Taylor Greene is tucked away in the background. Here is what they said 10:13 in the morning after the news broke. Hunter is not showing up to his closed-door deposition.
Ohio, let's see what they have to say. Initial reaction now.
We issued a lawful subpoena to the president's son that we expect him to come in and be deposed. This is a normal process in an investigation. This has been a serious, credible, transparent investigation from day one. We've published 4 bank memorandums. We've had countless press conferences. This is an investigation about public corruption at the highest levels. We have accumulated mountains of evidence that's concerning to an overwhelming majority of Americans. We have specific questions in there, and I think we're going to allow you in there to see the piles and piles of documents, of bank statements, of emails, of text messages that we've worked very hard on in this committee over the last 8 or 9 months. We expect to depose the president's son, and then we will be more than happy to have a public hearing with him. With that, I'll turn it over to Chairman Jordan.
Well, I would just echo what the chairman said. You know, we're disappointed that he didn't show up. I mean, he was just across the way at the Capitol. You think he could have come here and set the question? No. You do it in an open format now, you're going to get filibusters, you're going to get speeches, you're going to get all kinds of things. What we want is the facts, and the way you get the facts in every single investigation I've been involved in is you bring people in for an interview behind closed doors where you can get those facts. And then, as the chairman said, we'd love for him to come public. Finally, I would say this. Mr. Biden's counsel and the White House have both argued that the reason he couldn't come for a deposition was because there wasn't a formal vote for an impeachment inquiry. Well, that's going to happen in a few hours. We think it's going to pass. We think the House of Representatives will go on record with the power that solely resides in the House to say we are in an official impeachment inquiry phase of our oversight. And when that happens, we'll see what their excuse is then. They should have been here today, but once we take that vote, we expect him to come in for his interview, for his deposition. And frankly, we'll also, I think, look at contempt proceedings as we move forward.
Okay.
With that, we'll take your question.
Okay, we'll also maybe look at contempt proceedings as a throwaway line. Oh my gosh. They're not doing anything. They should have had a contempt document and vote already done. He's not here. If he's not here at 9:15, a contempt warrant is issued immediately. And we're referring it over to the DOJ. Legislative referral. And you see what they do about it. But nothing, man. They are so weak sometimes, it makes me embarrassed. And the reason we have to have a deposition is because it's more safer. No. We are Congress. We ordered you to be here. Act like Liz Cheney or Benny Thompson, for crying out loud. Get your butt here. He was standing across the street. He didn't show up. He snubbed Congress. We're voting on contempt. First order of business as soon as you walk out. Or if they don't have the authority to do that, then they shouldn't have bluffed, okay? Go do your stupid impeachment vote, which apparently just passed, which we'll cover next. And then issue the subpoena. Why did you do this? You just gave Hunter essentially a win. Let's see what the media says.
I just call his bluff. I mean, he's here and it's obviously not.
It's a bluff, exactly. What did he say? Did he just call your bluff? Did he ask that question? It's a great question.
For his interview, for his deposition. And frankly, we'll also, I think, look at contempt proceedings as we move forward. With that, we'll take your question.
Why not just call his bluff? I mean, he's here and he's obviously not wanting to sit for a deposition. This could be one chance to get to hear from him. Why not just call his bluff and see if he's willing to sit?
Because there's a way you do investigations, there's a way you're not. Every one I've been involved with, from clear back to the IRS targeting conservatives, to Benghazi, to the impeachment people, everyone, you do it in a way where they come in for private. This is what the Democrats did. Don Jr. had to testify twice in a deposition setting, 2 different committees. But somehow that doesn't apply to the Biden family? That's not how it works in our country.
Well, it's because the Democrats don't play around, Jim. They'll actually do stuff and throw people in prison for it and charge them with crimes. You guys just sit around and send letters.
It's supposed to be equal treatment, the same treatment under the law.
They don't play that way.
Biden said that his father had no involvement in his business dealings, period. How do you respond?
That's not what Devin Archer said. There was telephone, phone calls, meetings, dinners, you name it. We know what happened with Burisma in Ukraine in that December 4th through December 9th time frame, where Joe Biden goes and leverages conditions that American tax money on the firing of the prosecutor who was looking in to the executives of the very company Hunter Biden was on the board of. We know those facts.
Remember, Joe Biden said he never met with any of these people or talked to any of these people. That was the narrative before we began this investigation. Now we know he met with and talked to every single one of them. So the president hasn't been honest about his associations with these people who have been wiring millions and millions of dollars to Hunter Biden and the Biden family. Look, I think every American has a simple question. What did the Bidens do to receive the tens of millions of dollars from our enemies around the world? That's a simple question.
But Chairman Comer, do you acknowledge that you haven't answered that question and that you found no evidence of wrongdoing or criminal conduct?
We found some very serious evidence that you look at. No. The checks. There's 2 checks to Joe Biden from his brother that the money to give Joe Biden was through influence peddling. One was through the American. You have to touch it. No. Listen.
Loan repayments that we all saw. We showed you the loan documents.
That is. You don't understand loan documents. I do. Okay. If I wrote you, if you pay me back $240,000 for a loan repayment, I should have a check going to you for $240,000.
You're accusing Joe Biden's attorneys of inventing
the law firm that represented all the shell companies. That represented all the shell companies.
You think those lawyers have
What do you think? You're defending them. I mean, you're acting as
that's just a very serious crime to accuse.
Are you positive that money came from Joe Biden? You've read it? Are you positive? No. Look, we have a lot of questions. Next question.
Are you going forward with contempt?
I'll let you.
There's a process you have to follow. You have to file a report. So we will begin looking at that. Both the lawyers for the Oversight Committee, the lawyers for the Judiciary Committee will move in that
We have to file a report, fill out the form. I have to download the PDF and start filling it out.
direction. But look, when Congress asks you to come, you're supposed to come and testify.
Devin Archer testified.
Last thing, we also found
Jim Jordan wants to get the hell out of there. You can see him moving quickly for the exit.
checks from one of Hunter Biden's shell companies that were going into an account for Joe Biden monthly. They said that was a loan repayment. Oh yeah, everything's a loan repayment. Well, why did Hunter Biden will have an opportunity in deposition to come in and explain that?
In emails that you guys leaked from Hunter Biden's laptop.
I would like to have asked Hunter Biden about Mann violations. Sex trafficking women across state lines.
Thank you all very much. Thank you.
That would have been a good question. You don't seem to care about that.
Thank you, guys.
Chairman Comer, are you going to call on the sergeant at arms to go ahead and...
Honestly, it's very embarrassing. It's embarrassing. They're finagling with the media. They're fighting with these people. They should come out and say, first of all, the scenery is just pathetic here. Okay, they're on the floor with these they should have been on a podium very high, walked right out. James Comer said, that's it, we're done. We've been playing around. We said be here at the time, and now you're done. And we're moving forward with contempt. No questions. Go ask Hunter about it. That's it. Instead, they spend here, bickering with the media. It's really not good. So anyway, I don't know. I don't know why they can't figure this out. There is a lot there. But here is what they were waiting for. This is what the scene looked like. So holding Hunter in contempt. Here is what the Oversight Committee said. So I still don't know what they're doing about contempt. Hunter defied a lawful subpoena today, and we will now initiate contempt of Congress proceedings, is what they said at 9:51. Now, there will be no special treatment because his last name is Biden. Joe Biden and his family must be held accountable for their corruption. Okay. So Jim Jordan said that they're going to think about it and fill out some forms. And now Oversight says that they're going to move forward with it. We'll see. I'm not holding my breath on it. Now, here's what Joe Biden said, okay? They don't play around. when they're talking about Steve Bannon or when they're talking about Peter Navarro, they just threaten them with jail. Now, if you don't show up, we're going to put you in prison. And they're trying that with Bannon right now and Navarro. Here's Joe.
Talking to you so much today, you're not going to want to talk to him anymore.
Sir, what's your message to people who defy congressional subpoenas on the January 6th committee?
I hope that the committee goes after them and holds them accountable.
Should they be prosecuted by the
I
Justice
do,
Department?
yes.
Prosecute them.
Do you support term limits for the Supreme Court?
Yeah, prosecute them. Yeah, prosecute them. So apparently Jim Jordan and the rest of them, they're going to go and get an impeachment vote, and then they're going to come back. Here's one more from Comer, I think, after they were able to collect their thoughts after Hunter and his lawyer caught them flat-footed. Oh, he's here? He's outside? Oh, crap. So here's what they said. They came back out. Here's Comer.
Chairman Jordan and I have been very clear. We issued a lawful subpoena to the president's son. This has been a 10-month investigation, a credible, transparent.
See this? Much better scene. Okay, I like this much better. They're not being hounded by a bunch of chihuahuas barking at their heels. Bunch of media. Derp, 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 derp. Much better. Nicely done, guys. Good memo.
Investigation that has produced a lot of troubling evidence. We have lots of questions. Hopefully you all have had an opportunity to go in the committee room and see the boxes
James.
Of documents
they
that we've
care.
accumulated.
They don't care.
Tens of thousands of pages of documents. We have lots of specific questions. This is an investigation about public corruption at the highest levels of our government. The American people expect Congress to investigate this because I think one thing that Chairman Jordan's proven is the FBI, the DOJ, and the IRS, as we've heard from the whistleblowers, have all dropped the ball. So the House Oversight and House Judiciary Committee are conducting this credible investigation that an overwhelming majority of Americans want. We have specific questions for the president's son. He does not get to dictate the terms.
Sounds like he does.
Of this subpoena.
Sounds like he does. Sounds like he does. He didn't show up and you didn't do anything about it, so I guess he does. All right. Well, okay. I guess what can you say? Congress, doesn't have much to respond to now. We'll see if they get there. Hunty just snubs his nose at it. Shout out to Abby Lowell for, catching Congress flat-footed. They come out there bumbling like morons. Maybe we'll do contempt. Did they think he was going to show up today? What was their plan B? They didn't have one. And now they're still, finicking around with contempt. It's really a wild thing. So, all right, my friends, we're going to be here continuing to cover this. Thank you for joining us as we do. Thank you for hitting the subscribe button. If you want to follow along and sign up for our newsletter, or if you'd like to grab some new gear at the new Watcher shop, you can get your hats, you can get your sandals, you can get anything that's on the store that you can buy there at robertgovea.com/shop. Thanks for supporting the show. Thanks for getting some good gear. We'll look forward to seeing you back here on the next one. All right. And it looks like we have an impeachment resolution. And we do. We do indeed. Okay. So cool. So we can close out this story basically with this news. And it is interesting news. Let's see what to make of it. And it is our final segment. Biden impeachment inquiry approved. Congress issued the vote today. We're going to take a look at what happened, along with the resolution, H.R. 918, that is now out. We're going to read through it briefly and see what it looks like, but Tom Cole is going to be the person who introduced it for us. James Comer spoke about it. It got passed out of committee, and it's a big deal because, as we know now, Congress is saying we needed this anchored in. We needed this to give us the full authority of the United States Congress to go make people do things. And so even though Hunter just snubbed them and said, I'm not showing up for your useless subpoena, maybe this will now give them some power. So maybe now they'll just issue a new subpoena and say, oh, this time we mean it, Hunter. And so this is interesting news. We'll see if the Republicans can hopefully not botch this, but this is what we saw from the speaker. Mike Johnson posted this before the vote. He was feeling pretty good about it, thinking that he is going to have the votes. Turns out he did. Here is what he said today. Today, the House is voting to formally open an impeachment inquiry into President Biden. Says the facts don't lie. It's time to get the American people answers. Here's Joe.
Can you explain to the Americans
to Americans amid this impeachment inquiry why you interacted with so many of your son and brother's foreign business associates?
I'm not going to comment on that. I did not, and it's just a bunch of lies.
You didn't interact with many of their business associates?
I did not. There's lies.
One of Hunter Biden's former business partners testified before the House Oversight Committee Monday in a closed-door meeting. Archer testified that Hunter Biden put his father, who was vice president at the time, on speakerphone multiple times during business meetings.
Lies.
Archer said that Hunter Biden was selling the Biden family brand. In his view, that Joe Biden brought the most value to this brand.
It's just a bunch of lies.
And in the case of this Ukraine energy firm, Archer testified that he thought the firm would have gone out of business if they didn't have that Biden family association.
Lies.
Joe Biden was using multiple false aliases, fake email names, in his dealings about Ukraine during the Obama White House while his son was making money in Ukraine.
The evidence is so clear you cannot look away, and the Constitution requires the House to follow the truth where it leads. We have a duty to do this. We cannot stop the process.
Mike Johnson, Speaker of the House, launching the impeachment inquiry, and it turns out it has passed. Says here from Simona Teba, says breaking. The United States House just approved the impeachment inquiry into President Biden 221 to 212. And here is what it sounds like.
On this vote, the yeas are 221 and the nays are 212. The resolution is adopted. Without objection, the motion to reconsider is laid on the table.
All right, so there we go. We've got the impeachment inquiry approved, and there is going to be some hemming and hawing about this. Let's see what is inside of it. And we know that it was introduced by Tom Cole, and he introduced H.R. 918. And so since it's passed, we'll just take a look at what is inside of this thing. And again, you know, there's are oftentimes changes to these documents, and it may not be 100% final because, you know, Congress works. But this is what the document that I've been able to get looks like. And this is the filing, H.R. 918. The resolution that directs certain committees to continue their ongoing investigations as part of the inquiry into whether there is sufficient grounds. So we go from an inquiry, like a subcommittee inquiry, to a bigger inquiry, whether they can exercise the power to impeach Joe Biden. Here's the resolution that is now passed. Be it resolved that the Oversight Committee is continued and directed to conduct their inquiries to determine whether we can impeach Joe. This is part of the impeachment inquiry. You carry that on. Now, here's what we get. Here's the process. For the purpose of continuing the investigation, the Committee on Oversight is authorized to conduct the proceedings pursuant to the following rules. And we read through this, you know, a very similar analog to this when Liz Cheney was in charge. H.R. 503, when they said that the House Select Fake Committee was supposed to be comprised of a certain number of Republicans, 5 of them. They were not appointed. And in my opinion, that invalidated the whole committee. But Congress can do what Congress does, said the courts. So they say, here's how this is going to be organized. The chair of the Committee on Oversight is going to may designate an open hearing pursuant to this section. Then we'll have ranking minority and majority members saying that they shall be permitted to question witnesses for equal specified periods of longer than 5 minutes as determined by the chair. So we can have hearings, you get 5 minutes apiece. The time available for each period of questioning under this paragraph shall be equal for the chair and the ranking member. The chair may confer recognition for multiple periods of questioning, but you can't have more than 90 minutes. To allow for the full evaluation of minority members, the ranking minority member may submit to the chair any witness testimony, requests for witness testimony within 72 hours. Now, the ranking minority member of the committee is authorized, with the concurrence of the chair, to require, as deemed as necessary, subpoenas or otherwise. If the chair declines to concur in a proposed action, the ranking minority member shall have the right to refer to the committee for the decision about whether to exercise the authority. So the minority member has some recourse here. Subpoenas and interrogatories may be signed by the ranking minority member, And so the Democrats can also issue subpoenas and interrogatories. The chair is authorized to make publicly available in electronic form transcripts of depositions, so we'll get some of that, as long as there are redactions. Oversight Committee is going to issue a report on all of this in a way that they may deem appropriate. The chair may transmit to the minority for their review. Now, here's some of the things they can do. Investigative proceedings. Talking about 5 minutes of investigation. Again, don't exceed 90 minutes. The ranking member, and the ranking minority member also has some rules they have to follow. And it's a lot of technical stuff, right? Not that much interesting stuff. Technical. How much time can they have to question witnesses? Who's got the subpoena power rights, and so on. Now, the committee is authorized to create more rules, and this is what it looks like, right? Not a lot of interesting things in there other than technical proceedings about how this works. And I was even looking more for the scope. The proceedings. And so it's probably just referencing to the original scope. It's a continuation, right? Which is why it's not that interesting. It's basically a continuation of what they have done previously in September 27, 2023, which the inquiry was a much broader document. So it's largely continuing what we've already seen. And so obviously a big day. Nancy Pelosi says this is ridiculous, says that there is no respect for anybody on the right and their appreciation for the rule of law. She says, Republicans pushing impeachment, they're just doing that as payback and withholding aid for Ukraine. Says the longer Republicans take to provide aid to Ukraine, so Biden's impeachment is about Ukraine, I guess, the more women and kids are going to die. Here's Pelosi.
No respect for his own members.
I'm not sure if she's drunk or not. You can be the judge. Here's Pelosi.
At this difficult time for our country, when we have so many needs that we have to meet, so many challenges to democracy in Ukraine and in our own country, and that the speaker is going down this path, he says he has no choice. The fact is he has no respect. No respect for the Constitution of the United States, no respect for his own members, whom he's asking to vote for an impeachment with no basis. You referenced when we impeached the president a number of years ago because of his refusal to send the aid to Ukraine that was voted by Congress and he was supposed to send, but was threatened to withhold it unless he got certain favors done for him by President Zelensky. But he said to me, what's the problem with the call? It was a perfect call. Yes, it was perfectly impeachable. And so they have no basis.
Drunk, right?
And so their excuse for having no basis is they have no basis. And yet they're saying to these people, nearly 20 of them, maybe 18 of them are in districts that President Biden won. So it's going to be a hard sell for them to go home and say why they went down this careless path. But remember, the longer they take for Ukraine, more people will die, more women will be raped, more children will be kidnapped, and it'll be all on them. We have to get them to move.
Yeah, it's Republicans' fault that women are being raped in Ukraine. Got it. Thanks, Nancy. Got it. All right. So that is what the impeachment inquiry looks like. They want to talk about everything except Joe Biden's conduct. They want to blame everybody else for all of their ills. It's MAGA's fault, Republicans' fault, blah, blah, blah. More money for Ukraine, though. That is a consistent drumbeat from both sides. But good news from the right. The Republicans get something done. It's going to be an impeachment inquiry. I don't know what they're going to do with this. I mean, hopefully they have better showings than they're interfacing with Hunter, because that didn't work out so well for them today. But they now can get access to materials and do things that they said that they couldn't do before, and we'll see what that turns up. I expect it to be a lot because there is a lot here. They don't want to admit it, but it's true. My friends, we'll be here continuing to cover this. Thank you for subscribing to our channel, wherever it is you're watching this. Thanks for inviting someone to come over here, check the show out, say we cover the legal documents in depth, stuff that they're not going to see anywhere else. And I think it's important that they do understand what's happening because it's not good. Although today was quite a good day. We had some very good victories, including impeachment, including Chutkan losing. And so we'll be here continuing to cover, my friends. Thank you for joining us as we do. We'll see you on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. Biden's impeachment inquiry launched and passed. We've got Hunter snubbing Congress and kind of making them look like a bunch of idiots over there. We've got Trump objecting to any fast tracking, any expedited processing of his appeal, and Chutkan and Jack Smith lose jurisdiction over Trump's D.C. case. It was a fun one today, my friends. Chutkan is having a bad night tonight. Her and Jack Smith probably calling each other after probably a couple tequilas. Can you believe I had to do this one? All right, so we'll now hear from you, my friends. Thank you for your amazing support and donos, courtesy of our friends at watchingthewatchers.locals.com, our friends on the YouTubes, our friends on the Rumbles. Super grateful for your support. Thanks for the donos. Thanks for checking out the shop, the robertgovea.com shop, to grab some Watcher gear. And let's see who is in the house starting us off. We got Vientikis clipping for us. Thanks, V. We got Pinecone gifting Barbaric Brit a membo in the house. Pinecone and Barbaric Brit, welcome aboard. Spud says, I am so dedicated. I'm watching this while flying back from Las Vegas. Hashtag jet lag. Well, Spuds, hopefully you had a beautiful trip, my friend. You know, Vegas can be a lot of fun. It can be a lot of trouble. So hopefully you're doing great and you have a nice flight. Thanks for listening to us aboard the airplane. And hopefully you have a nice flight. We got Catherine Rex says, do you think the judge is feeling the heat? Oh, yeah. Chutkan is very unhappy about what's happening here. Very unhappy about what's happening. She's like, I have to do this, but not happy about it. Yeah, that's what it feels like. That's what she probably feels like right there. We got Rob S. is here. What's up, Rob? Thanks for the dono, my friend. Laughing, saying, ha, ha, ha. Thank you, Rob. Thanks for being here and for sending that one in. Voice says, Biden isn't on the ballot in New Hampshire. Well, I think that's just for the primaries, right? So he'll be on the ballot for the general, but I think it's just for the primaries, which it's rigged anyways. I think that they rigged it in Florida as well, and people like Dean Jackson are very unhappy about that. Hey, Freedom Express Media is here. Great YouTube channel. They sing for the J6ers stuck in the gulags out there in D.C., so make sure you're giving them a follow if you want to check in on them. I'm subscribed. I like to see when you guys are live. I pop in, say hello. I don't say hello, but I say hello in my mind. Freedom says SCOTUS takes up the 1512 charge that has a weight of 20 years. Trump and hundreds of J6ers have been charged with and or convicted of. Yeah, it's a great comment. It's a great comment, especially for the work that you're doing there, Freedom. Yeah, we're going to be continuing to see what they do on that. I'm hopeful that they find that corruptly has been misapplied and exploited by the DOJ to prosecute their political enemies. Good to see you over there. Glocky McGlockface says Paul Sperry on X has brought up the fact that a DOJ witness blew the whistle on Jack Smith paying bribes and securing convictions in Kosovo. I've seen that story, yeah, and I'm kind of waiting for that story to marinate, matriculate, evolve, grow before we dig into it. But I do have that saved, and I'm kind of waiting for some more to come out on that. We got Glocky McGlockface, thank you. Rob S. says, can't Donald Trump and did Jack Smith and all the witnesses that were gagged, weren't they forcing Jack Smith to reveal who the witnesses are going to be? Well, if they have a witness list, I have not seen it yet. I think it's hundreds of potential names, and I think that the real limiting factor was the reasonableness of the gag order, right? They said reasonably foreseeable witnesses are all included. And what does that mean? Nobody knows. Good to see you, Rob S. We got John Allen says, hey, Rob, Hunter's crack dealer here. Not that anyone is wondering, but still exhausted from my delivery of an 18-wheeler's worth of crack for a Hunty boy. Well, he was just in D.C., so he's probably looking for some crack. Says, be on the lookout for it in the news. He was stressed out, man. That press conference really took a lot out of him. May even have some found in the White House again, although I think that they realize that they need to be more careful on that one. Says, standard disclaimer included, this stream in its entirety does not endorse taking or doing anything like that. Anyways, needed to relax some more. Maybe the product seeped out. Says, I had trouble sleeping last night. Love the new merch store. I plan on buying some things, especially sandals, as a gift. I'm sure this will please his father. By the way, speaking of the product, the merch store needs some, quote, renewable products, such as coffee. Hint, hint. Not crack, though. As always, Rob, we appreciate you so much for everything you do. Yeah, would you guys buy coffee from the merch store? Is that something that you guys would be into? Buying something like coffee or something like that? John Allen, thank you for the nice donos. Hunter's crack dealer, rather. Jason Jackson says, I can't access the mind maps. I get the email, but I clicked the link. Sorry, we can't find what you're looking for. It may have been moved or removed. That's not good. Can you add a second link to locals? I will definitely do that, Jason Jackson. Sorry for the trouble. Yeah, I will definitely do that. And I don't know why that's happening. It should be fixed. We've got this from Wendy K. Says, Jack Smith's protests too much. His desperation is showing, from Wendy K. Knox says, happy Wednesday, all. I've been thinking about this a bit, and I cannot think of any special prosecutor who has charm. In trainings, especially in trial college, which, wow, you went to trial college? That's cool. It is always about telling the story of the case and appealing to the jury. Jack Smith has all the charisma of a hand towel. That's from Knox Bierman, and you're right about that. They're just capitalizing on the anti-Trump fervor in Washington, D.C. That's about it. We got GSD Lady says, they passed the impeachment inquiry, 221 to 212. Wendy K is saying, dude, you are being used by your dad, talking to Hunter. You are going to be the fall guy. You just need to roll on Pops, the big guy. Yeah, he was kind of falling on the sword, you know. My dad's not financially involved in anything. And he's innocent. And I was just a crackhead. Just trying my best. Zulu says, mic volume, bro. Yeah, I think I muted myself like a Zoom person. You're on mute. You're on mute. Everybody in the chat, you're on mute, idiot. Thanks, guys. Thanks, Zulu. I know. That's not my finest minute. CF, Christian Fellowship Rob says, what? Like Trump-Russia collusion and PP tapes that were falsely spread around? Here's their answer. He's there to answer questions, but he said he wasn't there taking any questions. So what was that about? C. Wolf says, the shameless speech by Hunter here is sickening. That he can stand outside Congress and lie to the public when he should go in and testify inside. He's not under oath when talking to the press, regardless of where he's standing, and he's only fooling the idiots. I actually thought he sounded kind of pathetic, like everything you know, like to hear the president's son come out, like, I'm under attack. Everybody knows the dude's a degenerate, right? Sounds like he's a whining baby, honestly. This one from R. Taylor says, if Hunter is so innocent, why not just go in and answer questions like an innocent man would do? Republicans aren't hiding, bro. Come to the light. Recovering addicts will tell you day in and day out that the truth shall set you free. And that's a great comment, too. I also can't stand how Hunter says that he's out there making amends and stuff like that. You know, in recovery, at least the way that I've interpreted it, my experience has been that you've got to, admit your past, essentially, right? You've got to actually do an inventory and acknowledge your part in the things that you have done. That's called your inventory. And every time you come out and you shame and blame and name other people and just put it on other people, you're doing yourself a disservice. You got to recognize your part in all of this. Hunter's not recognizing his part in anything. And I'm not saying that you have to, if you're in recovery, you have to plead guilty to everything. I'm not saying that at all. But this has been Hunter's, shtick his whole life. Blame everybody else. Fake artist, fake recovery, fake loving son, whatever he is, right? It's all just a political charade. So Catherine Rex says the Republicans have votes for the impeachment inquiry. We love it, Catherine. Good to see that one. R. Taylor says, did anyone read the Newsweek article? I was totally confused of what they were trying to twist, highlight, and hide. Can you read between the lines for us? Sorry if I missed it. Well, I missed it too. I don't think I saw the Newsweek article either there, R. Taylor. If it is relevant to a segment, I'm happy to read it, but I just don't know what we're talking about. Rob says, I read that something that Obama suspended habeas corpus and it allows people to be locked up indefinitely. That would allow police to hold whoever they want and release whoever they want. Is this true? Not that I've heard. I'm not hearing that that's happening anywhere that I've seen. But I need more context on that, Rob. We got Seawolf says, perhaps Jim Jordan and gang suspect pursuing Hunter is a fait accompli because the DNC is probably going to replace Joe anyways, and further House investigations will only bolster the DNC reasons to do so. NY says the female reporter was a plant. Afterwards, she was on a hot mic asking if the audio was captured to the male reporter who asked a question. I tried to download it, but they deleted the VOD. Yeah, they just go after her. They're like heat-seeking missiles. And the Republicans play their games by answering the questions. Wendy says, Comer and Jordan are like a liberal parent, threatening to ground, and they don't do it because it would be inconceivable to the parents. It's like, guys, just do something. Act tough for 2 minutes. C. Wolf says, kudos to Comer for calling out the reporter for defending Joe. The national media are Biden PR firms. The bias is so in your face that many regular MSM viewers cannot believe that the allegations against the Bidens are legit. The scope of the MSM mass deception is hard to accept for the blue-pilled. NY says, Rob, I think you're being a bit too harsh on Jim Jordan. He's the only Republican to date beside Newt Gingrich that held Democrats accountable. That's okay. Biden didn't get any positive spin out of this. In fact, the total sum of the coverage has been mostly neutral and slightly negative. They are trying a PR whitewashing of Hunter. It's not working. Even the liberal establishment think he is a leech. Sergeant Willie says, I wouldn't say drunk, but she's got a good buzz on, says Sergeant Willie. That's fair. NY says, funny how the reporter didn't pick up on, quote, he has no respect for the Constitution. He's been speaker for a few days. Asking for a vote on impeachment is the process. Unlike how she did, which was short circuit and sent articles of impeachment without an investigation. Hey, Crash is talking about a secret project, says the alpha test today was exciting, very, very exciting. Bravo. In keeping with my stated position, it's always better to ask permission than to simply assume permission, even when offering a compliment. Says I have several comments concerning the experience this morning that I would prefer to offer at a more family-oriented dinner table of the after party or the coming morning stream with your permission, that is. Of course, Crash, we'd love some feedback. We're working on some fun stuff that we're going to share shortly. But we had a little test this morning. So thanks, Crash. We'll definitely get into it. Jeremiah says, Rob, your frustration with Comer, Jordan, and crew is understandable. The reps are always playing flag football while the Dems are playing no holds barred, full contact tackle with corrupt referees. Yeah, I'd just like to see something. Not like, well, maybe we'll think about contempt. Oh, gosh. Jeremiah says, thank you, Jeremiah. KX, hey, KX, 250 FMX. Man, thank you for the very, very generous tip. Says, Rob, there is no way to explain how much I appreciate the intricate information and tools you give me. This is by far the most powerful legal on religious apologetic podcast available. Amazing comment, KX. Thank you for the very nice tip. And it's a really nice compliment. You know, I try to be useful. You know, I try to make things useful. I try to make them fun. I try to make them entertaining but also useful. You know, something that we can learn from, something that we can witness, something that we can share with somebody, even stuff that we can take and integrate in our own lives. So it's a really nice compliment, KX. It's a really generous tip. Thank you so much for saying it. Grateful that you are a member. Oh, non-religious apologetic podcast. Non-religious apologetic podcast available. Well, thank you for that, Cam. Yeah, we also try to stay focused as well. And I know there's a lot of other shows out there that are focused on a lot of other things. Nice compliment, KX. Thank you for that. Knox Bierman says Hunter's speech was definitely approved by the White House. His lawyer was also ticked off during an interview, stating he, too, was a member of the defense bar. So there. I think we played that yesterday. Yeah, he's like, I know what I'm doing, by the way. And he said that, Knox is a defense lawyer in Texas. And that's because I think Weiss was explaining to him that you just can't subpoena Donald Trump, right? He subpoenaed Trump, and Weiss said, this isn't a civil lawsuit, Abby, idiot. You can't do that here. Don't copy and paste your civil stuff in our court. And so he went on the meeting. He's like, I'm a member of the criminal defense bar, too. And, you know, he very well may be. I don't know. But, like, what happened today is not criminal law. Today was just political gamesmanship, and he beat the crap out of the Republicans with that. So, looks good. Knox, thank you for the very nice comment, my friends. Thank you for those very generous donos, supporting the work that we do here. Very grateful for that. We also want to say hello to our friends on X before we go over to our members only after party and stream. And we've got, oh my gosh, on X, we've got 62 viewers. Holy moly. Hello to our friends on X, man. It's so great to see you guys. I think that's a new record here. It's got to be Elon. Elon changed the tubes or something happened. I don't know what he did. But thank you to Elon and thanks to all of our X friends who is joining us here. We got Taco Bill. We got George. We got, nice comment. JB says, Salty Sarge says, if this show was a car, that's what it would look like. I'm not mad about that. That's pretty cool. You know, I'll drive it. I'll drive it, man. Not bad. We got M Money says, hey, thank you for the birthday shout out, man. Happy birthday to M Money. Happy birthday. Jack says Nancy's drunk on her afternoon martini as usual. JB says everyone is an abuser and abused. Janelle, we got Dorothy, we got TJ King, man, tons of comments here. And Kat Johnson says prayer for protection over Trump. And this guy, I can't even say this name, Lucky Jill, says, man, I already tried you at 1.5 speed, but you already talked too fast. I already had 5 cups of coffee. And so it's just a lot. We got M Money. We got Pseudo Station memes. Says, when Chutkan stayed the case, did she say that Trump was free from litigation burdens or additional litigation burdens? Seemed like a distinction she might hammer him with if she gets the case back and reconsiders any dates. Yeah, good question on that. The nuance there. I think it would be basically any litigation burdens you're freed from. He listed everything. And it sounds to me like it's everything except the gag order and release conditions. George says, if you do coffee, you got to do Hawaiian coffee. We have the best coffee in the world. Maybe I can hook you up. We got, well, John Allen has a coffee hookup too. That's why he's asking about it. And it's good coffee. I've had some. Danny McWilliams says, forgive me, Robert. That's all. You're forgiven, Danny. No problem. Cat 5 says, can I claim Zelensky and a couple of these asylum seekers as defendants on my tax returns? Dependents on my tax returns? It says, oh, wait, you do criminal law, not tax. Good call. Good call on that one, Cat 5. Drunken Senpai says, they're losing, they're scared, they're flailing. Keep fighting, everyone. The tide is turning. Almost 100 viewers at peak. Woo! Danny's talking about just a joke. Hey, we got a Marco Polo book out there from Fred. Says, hey, Hunter, look, if it's not MAGA Republicans, it's you. There's a whole book about it, man. And we got some other comments. V says, which one of Trump's guys did what he thought he needed to do to comply again? I don't know. I think many of them. And so, my friends, amazing. So we got 78 viewers now on the X platform. My friends, thank you for those great comments. How fun is this? And I love to see it. I think it's great that we're supporting X and, you know, the other free speech platform out there. We've got our friends on Rumble that we love as well. And so it's great to see hear from our friends on Rumble. We got Dog D's over there, White Sparrow. We got Cuse Chick. Cuse Chick says, thank you for correcting. Man, we got Indoctrinations over there. Amazing, my friends. And so it's so great to see, you know, activity on the other platforms. It's very, very, very good news. Very good news. So thank you for sharing that. Also on the X, we have the Watcher community. The Watching the Watchers community group looks like this right here. And you can join up on that one if you'd like to follow some other Watchers out there in the X universe. Cool place to do that. And so, my friends, that is going to be it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We do member streams there in the morning. So we'll do a member stream tomorrow. If you want to become a member, we'll see you tomorrow morning. But before we wrap it up, we want to say thank you to our mods and our meme smiths who help mod down the fort for us. Our friend Vientikis Prime clipping away for us along with John Allen, K-Bean, we got Just Cause, we got Playin' Hooky, Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, Janek, Dog Digger, and Donut Mind Me, all modding down the fort for us, along with our meme smiths, Jeegum Geegum, Sleepy Dog Lee, and Nathan, N810. My friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We would love to see you there. But if we don't, even though I will be sad, we will see you back here tomorrow, because together, with your help, we are going to, oh my, I got to start that over again. How did I do that again? All right, so that's the show for the night, my friends. We are going to come back tomorrow, and we need to see you here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. Get the sweetest of dreams you can muster, and we'll see you back here in the morning. Bye-bye.